When relationships break down, one of the biggest questions is what happens to the joint home. Whether you're married or just cohabiting, figuring out who keeps the house can be really stressful. I know a lot of people, myself, who've been in this situation who would not wish it on anybody, particularly when there's bad blood between the ex-partners. But don't worry, as always, I'm here to make the whole process really simple for you. Welcome back to my channel. My name is Cal, your personal travel size lawyer, here as always to break down complex legal issues into simple and easy to understand advice. And in this short video, I'm going to explain what happens to property in a divorce settlement, how ownership of the property is determined, whether you're married or unmarried, and what your options will be with the property once you have separated. I'm going to do all of that in just the next 9 minutes. So let's get started. Now in part one, we're going to look at divorcing couples with marital homes. And in part two, we'll discuss unmarried partners. So feel free to use the timestamps below to navigate the video as it relates to you. Now, I'm not going to ask you at any point to hit that subscribe button, only that you give me the opportunity to earn it with this video. So if at the end of the video you feel like you've liked or learned something of value, feel free to do so. Now, first we'll start by looking at what happens to the home in a divorce settlement. Now, in the UK, the division of property during a divorce is governed by the Matrimonial Causes Act. And under this law, the court's priority is to ensure that any financial settlement is fair and takes into account the needs of both parties. Now, when it comes to the house, the court will consider the following 5 things. The welfare of any children under 18. Now, the court's primary concern will be ensuring that the children have a stable home environment. That might mean that the parent who has primary care of those children will be allowed to stay in the house. Number 2, financial resources of each spouse. That includes income and saving and earning potential. Number 3 is the housing needs of both parties. Number 4, the standard of living before the breakdown of the marriage. And number 5, importantly, the contributions made by each spouse during the marriage, both financial and non-financial, such as taking care of the children, paying the mortgage, or maintaining the home. Now, the court has a lot of flexibility when deciding on what happens to the house. They may order that one spouse gets to stay in the home, or they may order that the property is sold and the proceeds divided between the two. Now, when deciding who legally owns the house, the court will look to see how the property was owned beforehand. More specifically, if the spouses were joint tenants or tenants in common. Now, you were joint tenants if both spouses own the property equally. If the property is sold, proceeds will be split, typically 50-50. Now, you were tenants in common if each spouse owned a specific share of the property, which may not necessarily be equal. For example, one spouse owns 60% and the other owns 40%. Now, if you and your spouse own the house as joint tenants, it's presumed that you both have an equal share in the property. If you own it as tenants in common, the division will be based on the percentage each of you owns. However, the court can override these shares if it's deemed necessary to achieve fairness in the financial settlement. Remember, the court has a lot of power and their priority is looking at what is fair. So now we've determined the ownership of the house. Now let's look at what your legal options are for the house after divorce, assuming you both can agree, of course, but we'll consider what to do if you can't agree later. Now, the options when it comes to the family home. Now, option 1, one party buys out the other. You or your spouse may wish to buy out the other's share of the property. This often happens when one party wants to keep living in the house, especially if there are children involved. Now, with this option, the value of the house is assessed and one spouse pays the other for their share. Now, option 2 is you sell the house and split the proceeds. If neither party can afford to keep on living in the house by themselves, or if you just want a clean break, then the house may be sold and the proceeds divided. Option 3 is to postpone the sale. Now, in some cases, the sale of the house might be postponed, especially if you have children. As you remember, the courts are reluctant to deprive the children of a family home. So one spouse, often the one caring for the children, if there is one, may be allowed to stay in the home until the children turn 18, after which the house is then sold and the proceeds divided. So that's if you and your former spouse can reach an agreement. Now let's look at if you cannot reach an agreement or they are refusing to cooperate. So if you and your ex can't agree on what happens to the house, the court will make a decision for you. Now the court has the power to 1, order the sale of the property, 2, transfer ownership to one spouse with or without financial compensation, 3, grant one party the right to stay in the house for a certain period, often until the children are grown. It's important to note that court proceedings can be costly and time consuming, so it's better to try and reach an agreement outside of the courts if possible. Now, what about regular unmarried couples who have separated? If you weren't married, your situation can be more complicated because the law doesn't automatically apply the same principles to the family home as it does with divorce. So when it comes to the family home, if you're not married, the key issue is who legally owns the property. And ownership is determined by the legal title of that property. So let's look at if both names are on the title deeds compared to if only one name is on the title deeds. Now, if both names are on the title deeds, if you jointly own the property, you both have a legal right to the home. However, the way in which you own it, either as joint tenants or tenants in common, as we discussed before, will determine how the property is divided. As with married couples, if you're joint tenants, the assumption is that you both have an equal share. If you're tenants in common, then the shares will be divided based on what agreed share you have when you purchase the property. Now, if only one name is on the title deeds, this is where things get a little bit tricky. If the property is only in one person's name, that person is considered the legal owner. However, the non-owner may still have a claim if they can prove they've made significant contributions to the property, such as helping pay the mortgage or funding renovations. This is known as a beneficial interest. Now, if you are a non-legal owner but you think you may have a beneficial interest, let's look at how you might be able to prove a beneficial interest. So if you're not on the title deeds but believe you have a share in the property, you'll need to show that you've contributed to the property financially, even if it's not your name on the deeds. This can be a difficult and pretty complex process, and it often requires going to court to prove your case. But the courts will look at factors such as direct contributions, i.e. did you help with the mortgage or the deposit or major repairs? Did you make any indirect contributions? For example, did you pay the household expenses whilst your partner paid the mortgage? And finally, the court will look at intentions. Was there an agreement or understanding between you and your ex-partner that you would share the property? And can you evidence that agreement? Can you show that there was an intention to share ownership of that property? So if you can prove these contributions, then the court may grant you a share of the property, even if your name isn't on the title deeds. So once you've proved you've had some ownership, if there is a disagreement between you and your unmarried partner on that share, then you will need to apply to the court under the Tolata Act to determine your share. This is the law that determines property ownership for unmarried couples. Make a note of it and research it if you wish. Under this Tolata law, the court has the power to declare what share each party has in the property and order the sale of the property if one party wants to sell and the other doesn't. That happens a lot with these cases, one party wanting to sell and the other party not wanting to sell. In this case, the court can make a decision for you. Keep in mind, though, that cases brought under this law can be expensive and complex. It's always better to try and resolve these disputes with your ex-partner or through mediation if possible. All right, so by now you should be aware of how ownership is determined for married and unmarried partners, how a beneficial interest can be claimed for unmarried partners, as well as what your options will be for the property going forward. But before I leave you, there are 4 important considerations you need to make when contesting joint-owned property. Do not skip or ignore these, they are important. Number 1, get your legal advice early. Whether you're married or not, it's essential to get legal advice as soon as possible. Tip 2 is to try mediation first. Going to court should always be a last resort. It's so expensive and stressful. A mediator is an impartial third party and will only consider facts. Tip 3 is to consider long-term impact. If you're fighting to stay in the home, can you realistically afford that mortgage and upkeep on your own? And finally, don't forget the mortgage. If both parties are on the mortgage, you're both still responsible for it, even if one person moves out, and failure to pay the mortgage could lead to repossession. Okay, that sums up the advice I can give you on this topic. Look, contested ownership of property, particularly at the highly sensitive time following separation with someone you once had strong feelings for, is a very difficult position to be in. But now you understand how the legal framework and what factors the courts take into consideration, you should have an idea of how to navigate the process with your ex-partner. And listen, if you've liked or learned anything of value from this video, drop me a like, I'd really appreciate it, or maybe even subscribe to my channel to ensure you have qualified legal advice in your back pocket at all times. Remember, while my content can and should be taken as reliable legal advice in general, it's not a substitute for specific legal advice as it relates to your particular situation, and so shouldn't be relied upon alone. I'll see you in the next video.